time, just a couple of minutes for each of you. What are the most important things people should take away from this webinar? Daniel King, we'll start with you.
I think, first of all, the key one is how far apart the two sides of the market were on this proposal. And I think that's something that, A, the SEC is going to have to take into account very extensively, but also sort of watch out when and if any final rule or any additional requests for comment come out, because depending on where the SEC gets to in its own assessment of how far apart everybody is, I think there'll still be issues on the table, and there'll still be issues that are going to impact one side of the market or not go far enough for one side of the market vis-a-vis the other. So I think that's probably the first one. And I think the second one is this is probably not once a final rule comes out, if at all, everything's fixed, and that'll be the muni disclosure world for the foreseeable future. I think this is probably going to be a fluid concept. The municipal securities market has obviously grown exponentially, and I think given the size of the market, it's something that now the door has been opened to the SEC and the MSRB engaging with both sides on how we improve disclosure. I think this is probably something that's going to continue to develop, and it'll be tested whether through enforcement or whether through additional comment or additional guidance. I think it's something that people are going to have to be alive to if they're working in this space over the next few years.
Rick Weber?
Well, the other observation I would make is that this rulemaking process was a poster child for failure to really comply with the Paperwork Reduction Act. That act was intended to have regulatory agencies do good faith cost-benefit analyses, including all the costs that the public would incur as a result of complying with an obligation to file any papers with the government or with a third party. And there were, besides hopelessly underestimating the actual compliance costs, which, as I mentioned, the proposed rules have, and the release proposing the rules made no effort to quantify the benefit. And anecdotally, we can all agree that if an issuer refinanced half of its debt from debt that was not subject to acceleration to debt that was subject to acceleration on a hair trigger, the people who own debt that was not refinanced should know about that. But if that comes up, if that occurs for 1,000 issuers out of 35,000, then a requirement that all 35,000 incur substantial costs in order to make sure that disclosure occurs, it just is not a very good application of cost-benefit analysis. And I will say, there's no reason we have to eliminate all risk from the market, or if we wouldn't allow public lotteries.